Hello friends, in the series on the income tax cases, today we will discuss the case of SUDHIR CHADHA versus the Assistant Commissioner of Income Tax. This case has been reported in 100 ITR. Tribunal short notes page number 56 and the matter has been decided by Delhi ITAT G bench. The date of the judgment is 28th November 2022. Friends, in this case, the notice under section 143 subsection 3 was issued to the assessee. And this notice was for the limited scrutiny. The assessing officer made the addition under section 37 for an amount of rupees 4,80,000 which the assessee, who was a medical doctor, has debited into profit and loss account as commission. And according to the explanation of the assessee before the learned assessing officer, that this commission has been paid and the TDS has been deducted to the parties for getting referral clients, referral patients from those persons. As all we know that there is a Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002, which prohibits all the medical practitioners from giving or receiving any benefits in their profession. And section 37 says that if anything which is prohibited in law cannot be allowed under section 37 of the Income Tax Act. So the assessing officer, by applying section 37, says that this expenditure is not allowed under section 37 because it is prohibited by the Medical Council Professional Conduct, Etiquette and Ethics Regulation 2022 and made the addition. But when the assessee appealed this matter before the CIT appeal, there were two grounds of the assessee. First, the assessee changed its earlier ground. Earlier, the assessee was saying that this amount has been paid as commission for referring the patients to the doctor. But at the time of the CIT appeal, he changed the nomenclature of this expenditure and said that this expenditure has been done and paid to the marketing agency so that there should be a better coordination between the doctor, medical assessee and between the patients. And the second ground which the assessee took, that this addition was not on the ground on which the case of the assessee was selected for scrutiny. The CIT appeal said that the assessee is changing its stance. It is giving different version before the learned assessing officer and different version before me. So the CIT appeal did not entertain the appeal of the assessee. The assessee went to the ITAT and with the same grounds. The ITAT held that as far as section 37 is concerned, the learned assessing officer was justified in making the addition because commission to the different people after deducting the TDS is a violation of Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002 because it prohibits neither receiving nor giving any benefits for referring the patients to the doctor. So as far as section 37 is concerned, the assessing officer was well within four corners to make the addition. But at the same time, the ITAT said that this was not the point of opening the case of the assessee under section 143 subsection 3 in this particular case. And in this particular case, there was a limited scrutiny in which this ground of addition was not being there. So the assessee was weak on its merit point, but as far as the technical ground was concerned, the assessee was well with his arguments that this addition cannot be made because this matter was not the matter of opening the case of the assessee under limited scrutiny under section 143 subsection 3. If the assessing officer has to make the addition on this ground, then he has to follow the proper rules and regulation, proper procedure, and have to take the permission from the commissioner before traveling beyond the grounds on which the scrutiny case of the assessee has been picked. So the assessee got its case only purely because of the technical ground that this matter was not covered under the notice for the limited scrutiny. Friends, again, this is a perfect case where we have to show in our notices, in our assessment, whether the due process of law has been followed by our fiscal tax authorities. At the end of this video, once again I am repeating the name of the judgment. The name of the judgment is SUDHIR, CHADHA, Assistant Commissioner of Income Tax, and this case has been reported in 100 ITR, Tribunal Short Notes 56. The matter has been decided by Delhi ITAT G Bench and the date of the judgment is 28th November 2022.